Dear students, yesterday, while dealing with section 60 of the CPC regarding the properties which can be attached, which cannot be attached during the execution, we discussed and I told you according to section 60, clause 1, subclause Z, I think. So, the stipends and gratuities given by the government or local authority, they are exempted from attachment, right? So yesterday a typical case came in the Supreme Court, a decision was also given. So in that casually I have put a question to the students asking that an employee, right, who retired, he did not vacate the government quarters. He was there for 4 years. So the concerned department, they have collected the penal rent and actually deducted the same from his gratuity and paid the rest of the amount. Is it correct or not? The response immediately was, it's not correct because gratuity should not be attached. So to remove this difficulty, so normally I am making this video, not more than that. You all know that it is relating to payment of gratuity act, but still suddenly the immediate reaction is that people are on the impression that attachment of gratuity is not allowed. It's not correct. Now I will deal with the case. So this case, while disposing the special leave petition or actually special leave appeal number 11,025 by 2020 on 15/12/2020, the Honorable Supreme Court of India, 3 judges bench, yes, Sanjay Kishan Kaul, Rishikesh Roy and Dinesh Maheshwari, they held that gratuity can be recovered as rent from the officer who did not vacate the official occupancy or official quarters even after retirement. Alright, you can read this case as this is Steel Authority of India Limited versus Raghavendra Singh and others, 2020. So we will be knowing Mr. Raghavendra Singh. So he is the respondent. He was a retired officer rank in the Bokaro Steel City. So Steel City, he was there after he was retired in the year 2016, but he did not vacate the official premises till 2019. So the Steel Authority of India imposed a penal rent along with the rent. They have collected the penal rent also. It came to an amount of 1.93 lakhs. Right, before settling the pension and other things and also gratuity, they have deducted this amount from the gratuity and actually they have paid him the remaining amount. Normally, you may be knowing, central government it gives 10 lakhs or 12 lakhs as gratuity. Out of this, they have deducted this amount. Now, he has filed a case before the High Court of Jharkhand, and High Court of Jharkhand basing on section 13 of the Payments of Gratuity Act, which says no gratuity under the Act shall be liable to attachment in the execution of any decree. But here it's not a decree, it's only debt, or it's only for the default. Right? Even section 14 says it has no overriding effect. So CPC should be followed. Right here, it is not a debt, no execution of petition has come. Mr. Raghavendra Singh, even after retirement, he unofficially or he, without caring the orders of the Steel City, Bokaro Steel City authorities, he continued to stay. And of course, normally in the first year, general rent will be, nominal rent will be collected. In the second year, penal rent, third and fourth year, definitely penal rent has to be collected. Is it not? But the Honorable Jharkhand High Court said that no, the gratuity, it's a personal amount. Personal amount, how can you deduct the same? Since he is an employee, you cannot do the same like that, they said. But of course, Steel Authority of India Limited has come before the Supreme Court by filing an appeal, SLP. Now, please remember, the Supreme Court held that, basing on some previous cases also, ONGC Limited versus VU Warrior 2005. In this case, the Supreme Court clearly stated that gratuity can be recovered, gratuity can be deducted from the salary, can be deducted when the official becomes Okay, same thing. Here the employee occupied the quarter beyond the specified period. Definitely the period of rent can be adjusted by deducting the same from the so-called gratuity. So basing on that case, now the Supreme Court definitely added and accorded, and there is no necessity. So he has overthrown the so-called High Court judgment and said that penal, of course, the rent can be collected. So only saving clause by the Supreme Court is that the penal rent may not be collected because already is an employee, he stayed there. Only thing is he has stayed over time. Therefore, please collect only the so-called nominal rent. Nominal, that's all. That much of leverage was given to him. Anyway, the claim of the sale or Steel Authority of India has been accepted that gratuity can be deducted if the man becomes a defaulter in the payment of rent or other things. So even payment of gratuity in Act 1972, of course, what is that? It is a scheme given for the employees to get the gratuity having worked for so many years, either in factories, mines, gold fields, and other things. You may be knowing, if the institution is having more than 10 persons, such are then only they are eligible for the gratuity. Of course, government employees definitely they are eligible for the gratuity. So please refer to Payment of Gratuity Act 1972, particularly section 13 and 14, and you will be definitely coming to know that unless an execution petition is there, so gratuity can be deducted. If there is an execution petition, if there is an attachment, definitely you cannot go on the gratuity because it is the personal amount of the JDR, judgment debtor. So please know the difference and enrich your legal knowledge. Ultimately, what I want to tell you is Payment of Gratuity Act says that the amount can be deducted, but according to section 60, if any execution petition is there, if any decree is there, you should not attach the gratuity amount. That is the main difference, right? Please know this. This much is enough. Thank you.